The second ratio decidendi, my lord, that we deduct from Litako is this. It says that in Ndlovu, the provisions of Section 3.2 of the Hearsay Act were glossed over. And this we find, my lord, at page 445, paragraph F to G. And it states, in Ndlovu, the High Court, the provisions of Section 3 in brackets 2 of the Act, and by the Act they mean the Hearsay Act, were glossed over. That subsection provides as follows, that Section 3.2 in brackets, 3 in brackets 2 of the hearsay evidence provides as follows. The provisions of subsection 1 shall not render admissible any evidence which is inadmissible on any ground other than that such evidence is hearsay evidence. And the final ratio that we deduce from Litako is the following: that the wording of Section 219 of the CPA, 219 capital A, of the CPA provides the admission of the evidence as stated at 446 H2I as follows. Evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall be admissible against him. That is what we refer to when we were espousing the legislative framework. Now, I address the issue at point, my lord, which pertains to the executive statement. And we say in paragraph 5.1 of our heads, my lord, the executive statement exception has been succinctly articulated by the Constitutional Court in S versus Mutlongo, S versus Nkosi, 2015, what's this in bracket? I'll come to that, my lord. BCLR 8687 Constitutional Court as follows, and I quote, at common law, there is an exception to the exclusion of extracurricular statements of the co-accused if the statement constitutes an executive statement by an accused. It may be admissible against co-accused if it was made in furtherance of a common purpose or conspiracy. There must be other evidence, that is evidence aluende, to establish the existence of a common purpose before the statement can be taken into account. The state would have to pronounce on whether the common law exception survives a finding of constitutional invalidity of the admissibility of extracurricular statements of an accused against a co-accused.